Every day in the USA, people find themselves in court.
That hasn't been signed yet.
Oh, well, I'm not doing it today, so. We will go on the record in the matter 25 CF 96, State of Wisconsin versus Cody Erickson. This date appears through Assistant District Attorney Jose Villard in person. Mr. Erickson appears in person in custody. His counsel, Micah Paul, appears by video conferencing. We're set today in this matter for two things. One is a preliminary hearing and one is a bail bond motion. And we are in victims' rights compliance?
Yes, Your Honor.
Okay, all right. So with regards to this matter, Mr. Paul, is this going to be a waiver of a preliminary hearing?
It's not, Your Honor, and it's a little bit more complicated than that. It appears, my understanding is that the state and I are, we have this case resolved. Mr. Erickson intends to enter a plea to 4 of the 5 counts as charged. My additional understanding is that there is, that the state, at least as of last week, had an issue in regards to victims' rights compliance. And so the state's position was that we would be requesting the court hear Mr. Erickson's pleas today and set sentencing for a later date. I don't have any objection to that with the understanding, and I think the state is on the same page with me, that Mr. Erickson would be released on a signature bond pending sentencing. If the court is willing to do that, like I said, I don't have an issue having Mr. Erickson enter his pleas today and have sentencing at a later date. But that's kind of the posture of the case, if you will.
Thank you. I'm not inclined to do that. I had no notice that this was even a possibility. I need to have notice so that I can put it on my calendar and I can ensure that there is victims' rights compliance when there are any pleas and or sentencings. So what I can do is set it for a later date and time. This is Mr. Villard's. I'm just had my whole week open up September 15th. Except for September 16th in the morning is used by other judges.
Depending on what the court, like what time the court's looking for, I have a somewhat open calendar that week as well. My request, if the court is inclined to do that, would be that the court, I believe Mr. Erickson would be willing to withdraw his speedy trial demand at this point, but I would ask the court to hear our argument on the issue of bond today, and then we can set it for a plea and sentencing at that later date. I wouldn't have an issue with that.
All right. So how about September 15th at 10?
The morning of September 15th is one of the only times that I'm not available that week.
September 15th at 1?
That will work.
All right. September 15th at 1 p.m. And now I will hear bond.
So, Your Honor, the request would be that the court modify Mr. Erickson's bond to a signature bond in a more significant amount than the current bond. I believe that the bond is currently set at $500 cash. Mr. Erickson is wholly unable to post any amount of cash to effectuate his release. He has been sitting in Burnett County Jail for, my understanding, is over a month at this point because he has been unable to post any amount of cash bond to effectuate his release. His indigency has rendered even a low amount of cash bond excessive under the Eighth Amendment, and I would ask the court to modify bond and allow Mr. Erickson to be released on a signature bond. I think an amount of $5,000, even $7,500 would be an appropriate amount. But again, even a reduction to $100 would still require Mr. Erickson to remain in custody, and so I'd ask the court to set a signature bond. Mr.
Well,
Erickson,
he's
sorry.
not sitting a hold, and he's not,
He is-
I thought he was revoked.
He is not sitting a hold and he is not revoked.
He's still on probation?
So he had a sanction. My understanding is that the sanction has elapsed and that he is no longer on any sort of hold.
All right. Argument, Mr. Blard.
Your Honor, given the fact that Mr. Erickson has been sitting for over a month and that he has one failed missed appearance from 2 years ago for only a few days at that time, state would not object to amending this to a signature bond. However, would iterate to Mr. Erickson that we would request that we have no contact with the victims of any kind and request a high signature bond to hold over Mr. Erickson so he understands that he is still on condition of bond and he needs to abide by that.
I have heard the arguments and I have, I'm taking judicial notice of the past cases involving Mr. Erickson. It seems like he's been in a revolving door for the last year or two with getting charges and then pleading and then getting more charges and then pleading. I look back from 2023 and then 2024 and then now 2025, it's the same thing. Based upon that, I'm going to deny the bond modification request. We will have his plea and sentencing on September 15th at 1, and at which time the court will determine the sentence and or he will be released after he pleads to any charges. I'm going to guess there's a recommendation for more probation.
Yes, Your Honor, coupled with the DJOC.
Yes, I have a copy of the DJOC in front of the court. So he'd be pleading guilty to count 3, child abuse intentionally cause harm, and the OWI second, and what other, the 2 batteries?
Yes, Your Honor, it'd be count 1 and 2 for the batteries. The DJOC would be for count 3, and then the OWI second, and we would DRI count 5.
At this time, if he would be released, doesn't he live with his grandparents, and doesn't this involve that?
I don't have any information regarding that at this point, Your Honor. I haven't spoken with him specifically regarding that.
And then, Mr. Paul, I'm going to need that information for his plea and sentencing to determine whether or not grandparents will allow him to move back or where his residence or living situation will be.
Understood,
Okay.
Your Honor.
All right, thank you. We'll see you on September 15th.
Thank you, Your Honor.
You made a copy for me. Thank you.
Wanted to see your watch.
Never had anybody do that.
What?
Let me see your watch. Well, I appreciate it. I like your tie. Is that Jerry Garcia?
It is.
I know, I like it too. It's very spiffy.
Should get more Jerry Garcias. Coles. Coles flooded my wardrobe for a long time.
We will go on the record in the matter 24 CM 209, State of Wisconsin versus Anthony Thayer. The state appears through Assistant District Attorney Jose Villard in person. We have Gregory Amon, who is defense counsel in person with Mr. Thayer. We're set today for a plea and sentencing. The parties have reached an agreement. The court has in front of it a plea questionnaire waiver of rights form. Mr. Amon, can you please recite the agreement for the record?
Yes, Mr. Thayer is pleading guilty to count 1, criminal damage to property. Count 2 can be dismissed and read in. That's the disorderly conduct charge, joint recommendation for withheld sentence, 1-year probation, programming per agent, including payment of restitution, court costs, DNA surcharge, and sample.
Are we in victims' rights compliance?
Yes, Your Honor, I do believe we are.
And I don't see any requirements request for restitution, is there?
No, Your Honor. Attempts were made to contact the victim, but we never heard back regarding any restitution requests.
Okay, all right. So, Mr. Thayer, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes,
Did your attorney go over this document with you thoroughly,
yes,
essentially word for word,
yes,
and you understand everything completely?
yes,
Is that your signature on the second page?
yes,
Attached to this document are the jury instructions for criminal damage to property. Did your attorney thoroughly go over those with you,
yes,
and you understand them completely?
yes,
You're 33 years old, you have 11 years of schooling, you do not have a high school diploma or equivalent, but you can read, write, and understand the English language, correct?
yes,
No alcohol, no drugs, no medications, no mental illnesses or disorders, correct?
yes,
Did your attorney thoroughly go over with you what the state would need to prove your guilt beyond a reasonable doubt?
yes,
Did he go over with you the maximum possible penalties you face?
yes,
Because you're charged with crimes, you are entitled to constitutional rights. And each of the rights is listed on the plea questionnaire. Did you go over those rights thoroughly with your attorney?
yes,
And do you understand them completely?
yes,
And do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
yes,
Now, did you review the criminal complaint with your attorney, in particular that section called the probable cause section that basically says what happened that day and why you were charged with crimes?
yes,
For the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did cause criminal damage to property of another?
yes,
And here, the state would have to prove on or around October 26, 2024, you intentionally caused damage to the physical property of another, a window out of the front door belonging to KJM. And that was without KJM's consent. Do you understand what the state would need to prove?
yes,
Do you understand maximum penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
yes,
Mr. Amon, did you go over the probable cause section of the criminal complaint with Mr. Thayer?
I have,
May the court use that as a factual basis in this case?
yes,
Thank you. Has anyone made any threats or any promises to you, Mr. Thayer, for you to plead guilty to this charge?
no,
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Do you understand that there is a recommendation to the court here, and with regards to that recommendation, I'm not bound to follow that.
yes,
I could sentence you to the maximum penalty if I thought it was warranted. Do you understand that?
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
So no one has made any threats or promises to you to enter the plea?
no,
You're doing so freely, intelligently, and voluntarily?
yes,
You fully understand what you're doing here today?
yes,
Did your attorney represent you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Are you satisfied with his services?
yes,
Do you have any questions for the court or for your attorney before we proceed?
no,
As to count 1, criminal damage to property, how do you wish to plead?
guilty,
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Villard.
Your Honor, this sentence is appropriate based on circumstances surrounding this incident. This is a criminal damage to property case. The defendant broke out the window of a front door. We believe that a withheld sentence of 1 year of probation is appropriate and ask the court to adopt. Thank you.
Thank you. Mr. Almond.
not a big surprise that Anthony was extremely intoxicated, and when I read the complaint, it's kind of a who's who of people that get drunk and fight. But the court's well aware of Anthony's situation and particularly improvement for his kids over the last several months. He looks good, he acts good, he seems to be responsible when I'm dealing with him. And I think he's on a different path. And you know, as I told him, like everybody else, we're one bad decision away from screwing things up, but I think he's doing really well right now, and I think this is a great result for him.
All right, thank you. Mr. Thayer, is there anything you want to add, you want to state here today?
No, Your Honor.
When was the last time you've had a drink of alcohol?
I think it's been this last night that I was in jail.
It's the last time you were in jail,
Yeah,
last October?
yep,
And you've been working pretty hard at improving your life and what you do with yourself and your kids?
yeah, I've been working hard, staying sober, working, taking care of my kids, doing what I can to stay out of trouble.
Okay. And this all involves family, right?
Yeah,
For the most part, they're all family.
yep,
And it was a night that got out of hand, right?
yeah, everybody was intoxicated and, yeah, it just got out of hand. Everybody's all good now, so.
Now, have you talked with KJM and possibly paid for a new window or door?
I've talked to them a couple times, but we never got to talk about that situation particularly yet. Kind of both been busy and stuff, so
Have you mended fences? You have made up?
yeah, we made up and stuff. We're good.
Okay. Anything else that you would like me to know?
No.
All right, thank you. In looking at the facts of this case, first I have to determine, is this a very serious matter? What's your criminal history? Do you have needs for rehabilitation? Do you have needs right now for services? I have to look at needing to protect the public, and that means the community as a whole. That means KJM and others who may have been at that party that night or that gathering that night before I determine sentencing. This was a gathering where I believe for the most part, there were family members there. I don't know if you were what you were hanging out for, what you were doing, but alcohol was involved. And it got way out of hand and way out of control. And then a fight ensued, and the window and the door got broken. And so I know from the past year, the different things that you've been doing in different arenas in your life to make significant and positive changes. And you've done a great job at doing that. You knew you needed to step up and step up for your children, step up for your family, and step up for yourself. And you have done that. I don't believe you have an extensive criminal history. There may be a case or two that's been in front of me since 2017. I can't recall. I do know that that you're not one to get into significant amounts of trouble, at least in this county, in front of this court. This occurred almost a year ago, October 26, 2024. There have been no other allegations of criminal conduct or any types of issues that would cause you to go to jail or to get into legal trouble. So what the court is going to do is, although I do believe probation is a good tool and it can provide lots of services, you've been receiving a whole lot of services in another area of court. And so you're doing very well. So I'm not going to follow the recommendation. I'm not going to put you on probation. I don't see a need for it. You're addressing the issues that you have, and you're putting, your life first and forward, and you're taking control of your life. You haven't had a drink of alcohol, as you're telling the court, since the date and time you were arrested. It tells me that you understand that this is serious, and you understand you need to be sober for your children and for your family. Hopefully you're going to talk with KJM and see if there's a way that you can make that right and fix that situation. But it sounds like you've mended fences. It sounds like you're trying to get along and let bygones be bygones, and know that they shouldn't drink to that level of intoxication again, because little things happen and then fights break out. So what I'm going to do is I'm only going to assess court costs and fees, $443. count 2 is dismissed. You have, did you pay your attorney's fees yet?
I was out of work for a month on work leave, so, and I just got back to work, so I'm gonna start paying on them now.
I would say that you have to, because not only will I enter a civil judgment against you, you're always going to owe these fees and your attorney's fees, but you could sit up to 6 months in jail. And if I don't
Okay.
start getting the payments and getting this paid off, I will issue a warrant and you could sit time in jail. You don't
Okay.
want that. I don't want that. No one in this room wants that. You need to be there for your kids. You need to work and you need to support them. So what I'm going to say is at minimum, you need to make $200 a month. And that can cover your attorney's fees and the court costs and fees, et cetera. But you need to start making a payment of $200 a month. First payment is due by the end of September.
Okay,
Okay? And then $200 thereafter until everything's paid off in full. All right?
okay,
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Continue to do what you're doing, Mr. Thayer. Continue to take control of your life and be present for your children. I am ordering that you provide your DNA. You at least have to go to the jails receiving to see if they need that. You may be able to request it be expunged through a written letter to the Department of Justice, not to this court, but to the Department of Justice, okay? I believe that covers everything. I'm going to sentence you to 2 days of jail. You have 2 days of jail credit. So that's time served. You might as well get that credit for that. Anything that I'm missing, Mr. Villard,
Not from me, Your Honor.
Mr. Almond?
No, Judge.
All right. Thank you. We
Thank
are.